Good afternoon, everybody. Thank you for joining us today on our Busting GDPR Myths live webinar. I'm Alison Smith, Head of Marketing at Maximizer CRM. So today, before we kick off with our speakers, so just for those that are not that familiar with Maximizer, we're a global software company, and we inspire our customers to feel confident in growing their businesses with our personalised CRM solutions. So today we are going to talk through GDPR basics, and then we will be looking at sort of the top myths that we quite regularly come across. So we'll run through those, and we've also we've got a poll running today. So we'd be very grateful if you could answer the quick question that's available through the poll throughout this webinar. And the question is, where are you on your GDPR compliance journey? So it'd be good to get an understanding as to where everybody is on that journey. And please also do ask your questions. If you put them in the questions block, just type them in. We'll keep track of them. Hopefully we'll have time for some questions at the end. And then what we will also do when we send out the recording of the webinar, we will also compile a question and answer response sheet so that we've got answers to all those questions. So just to briefly introduce you to our two speakers today. So we have Anthony Young, who is Director of Bridewell Consulting. Bridewell is a company that we've been working with on our own GDPR compliance, and Anthony has been helping us out on that side of things, and also on the resources that we have available for our customers. We'll talk about that a bit later as well. So Anthony has worked within information security for 18 years before starting Bridewell in 2013, and is obviously in great demand over the last year or so. We also have Mike Richardson, our Managing Director for Maximizer EMEA. And Mike has been with I've moved on what I shouldn't have done then. Mike has been with Maximizer since 2000 and has headed up several of the business functions with EMEA, so has got a great perspective on all aspects of business and obviously an in-depth knowledge of the value of CRM, and has been working with myself on our own GDPR compliance journey. So now I'm actually going to hand the reins over to Anthony, who's going to take us through the first part of the presentation. So Anthony, over to you.
Thank you very much, Alison. Hello, everyone. Yeah, I'm Anthony Young. I'm a director at Bridewell Consulting. So we're, as Alison mentioned, we're an information security and risk consulting firm. At the moment, yeah, we're very busy, obviously, in helping a number of organisations through from small SMEs to very large global enterprises in getting ready for the GDPR, which comes into force on the 25th of May. So I just thought I'd start off with sort of giving a bit of basics on sort of what the GDPR is and the differences between the sort of GDPR and Data Protection Act, and then we'll go through sort of some of the myths. So it's not long now until the 25th of May, and there's been a sort of a 2-year grace period for companies to implement the GDPR. But we have seen a mad dash over the last 6 months as companies of all sizes are scrambling now to get ready. You've probably seen there's a number of different communications coming out from organizations with updated privacy notices, addendums, and sort of re-permissioning and different areas as people are trying to get up to speed for the 25th of May. So the GDPR is replacing what was the Data Protection Directive. The directive was a set of guidelines that were set out by the EEA, but they were implemented in different countries in a very different manner. So in the UK, we had the UK Data Protection Act, but in other countries, we had different legal laws being put in place, and it was all very sort of unjoined up. Therefore, the privacy laws in the UK would be different for the privacy laws in France and Germany. Whereas with the regulation under the General Data Protection Regulation, this is going to harmonise laws across the EEA and make sure that data is treated in the same manner across all of the EEA countries. Another reason that we're seeing the change is that the directive has now become very outdated. It originally came into force in 1995 when the world was a very different place from a digital and data perspective. Nowadays, data is big business, as we've seen from the rise of companies such as Google and Facebook, which very much weren't around, and there wasn't this drive through data mining, data collection, data processing that we're seeing nowadays. So there's a need for a change in the sort of legislation. Another sort of driver for it has been sort of the huge increase over the last sort of 10 years in data breaches, which has meant that the rules now need to change to keep up with the change in the times. A lot of companies actually starting to take a lot of care about protecting people's data, and we need to make sure that the laws are making companies really do sort of take that into account. And the large fines which the GDPR brings in allows sort of companies of all sizes to wake up to the importance of protecting personal data. The GDPR also will bring into place for the first time mandatory reporting, which will give us a great picture of how bad a problem sort of information security and protection of personal data is across the EEA. Lots of mandatory reporting have been in place in regulated industries, but this is the first time that we're going to see mandatory reporting for data breaches across the whole of the EEA. So it's going to be quite interesting to see exactly sort of how bad security problem is, and it will also drive more sort of security controls to be put in place. So I thought we'd go through some of the sort of differences between sort of the Data Protection Act and the GDPR. So the Data Protection Act had 8 principles. The GDPR has actually gone down to sort of 6 key principles. There's 2 principles which have been sort of removed from the GDPR, but they're actually expanded on as articles further on in the actual GDPR itself. The first is to process data in accordance with data subjects' rights. So there's further rights for data subjects which are called on within the GDPR. And the other one is to not transfer outside the EEA without adequate protections being put in place. And again, this is covered in a lot more detail within the GDPR and sort of further articles, as there's a lot more data processing going on cross borders nowadays. The biggest change, and the one which is sort of causing the biggest difference, I suppose, between GDPR and Data Protection Act is the one we've got highlighted at the very bottom under GDPR number 2, which is data controller must now be able to demonstrate compliance with 1A through to 1F. So it brings in the principle of accountability. So with accountability, each organisation has to be able to demonstrate that they are complying with points 1A through to 1F. Therefore, companies can no longer just say, yes, we are processing data fairly and lawfully and transparently. They've actually got to be able to demonstrate it. They've got to be able to demonstrate they've got appropriate information security controls in place. They've got to be able to demonstrate that not holding data for longer than is necessary, and that's your being able to keep your databases accurate and up to date. So therefore, that's the big change, which is driving a lot of the sort of changes in sort of process. Some of the other sort of headlines you would have heard in relation to GDPR is around the fines. That's the thing which a lot of organisations have been sort of hanging up on, the fact that fines could be up to 20 million euros or 4% of global turnover. It's probably unlikely that the fines will be sort of stretched to the very maximum, but there is the capability for the supervisory authorities to be able to go after organisations with large fines if they keep ignoring the data protection principles under the GDPR. There's also further rights for data subjects, including the right for data portability. So organisations will need to be able to pass data, personal data held on a subject, to another similar organisation if requested. If an individual asks to see that what data is being held by a company, you have 1 calendar month to be able to respond. That is actually obviously already part of the Data Protection Act, but under the Data Protection Act, you used to be able to charge £10 for that. Now that's free, so organisations will maybe have an increase in subject access requests. Also, with the amount of publicity around the GDPR, a lot more individuals are now aware of what their rights are under the GDPR. So it's the rights and the fundamental areas is one that people will be sort of using more often. Another headline area is the piece around having a data protection officer in place. So public sector organisations have to have a data protection officer in place, and organisations which process large volumes of personal data would also have to have a data protection officer in place. Organisations that process a lot of personal sensitive data would also need to have a data protection officer in place. When you put a data protection officer in place, it needs to be somebody who is suitably skilled and trained in data privacy. It doesn't have to be somebody within your organization. It can be outsourced or done through a service contract. So there's been quite a lot of organizations now offering that as a service these days. A new area as well is the right to compensation and liability, which has been brought into the GDPR. So this is for this is for individuals to be able to claim compensation and liability payouts if organizations have been processing their personal data not in line with the GDPR. So there could be quite an increase in areas around there. So I just wanted to sort of quickly spend a bit of time going through sort of the different myths that Alison mentioned that we've been hearing over the last sort of couple of years. The first one is a lot of organisations saying, we're too small, this doesn't apply to me, this is only aimed at larger organisations. This is certainly not the case. If you look at the scope of what the GDPR covers, which I'll just put up on the screen now, the only areas or the only bits which sort of fall outside the GDPR is personal data that is used in the course of an activity outside of the EU law, personal data that's used in doing border checks, checking asylum and immigration status, personal data that's used in relation to purely like a personal activity. So if you've got your address book at home and you're just using that for keeping data on your friends and family, that would obviously be outside of GDPR. And then personal data used for the purpose of crime prevention. Everything else falls within the scope of the GDPR. So here we've got on the screen, it's anything that's being automatically processed, any data that's being automatically processed, either fully or partly. If it's being part of a filing system, that could be a filing system in your office, a paper-based filing system. That could be in your emails, so within Outlook or within an email system, or it could be in your normal sort of just filing on your desktop or on your servers. So it's very wide sort of ranging. One of the other sort of changes, I suppose, with GDPR over sort of the Data Protection Act is it now brings into play your data processors as well as your data controllers. Under the Data Protection Act, it was very much aimed at data controllers. A data controller is an organisation that does what it says really. They control how the data is collected and how that data is processed. So they will state what happens with the data. With a data processor, they can only act on a data controller's instructions. So a lot of companies nowadays are using cloud organizations, and they're very much sort of acting as a data processor. But the GDPR applies to data processors as well as data controllers nowadays. And any organisation that's within the EU falls under scope of the GDPR, and any data controller or data processor that's not established in the EU but offers any goods or services with it to data subjects in the EU, or does any sort of monitoring or processing or behaviour within the Union, will also fall under the bounds of GDPR. So myth number 2 is very much one we've heard a lot of, is that, we need to get consent and we need to repermission our entire database because we have to get consent from everyone. Well, there's actually 6 different legal bases to process personal data, which I'll just put up on the screen now. So the first one is consent. So data subject has given you consent for one or more specific purposes. Processing is necessary to meet the contractual obligations entered into with a data subject. So if you have a contract in place with a data subject, that can be your legal basis. The processing is necessary to comply with legal obligations of the controller. So if you've got to process your payroll and you've got to report certain data to HMRC, then that would be sort of meeting your legal obligations there. You've got processing is necessary to protect the vital interests of the data subject. This is for the health services. If they've got a data subject who they need to resuscitate or take blood from, or they need to be able to do something which was going to be in the best interest of that data subject from a health perspective, then this would be the legal basis for processing under vital interests. Processing is necessary for tasks in the public interest or exercise of authority vested in a controller. So this is for public interest, the public sector, and also for those journalists or anyone publishing sort of stories or doing scientific research. They can use that particular sort of legal basis on there. And the last one is processing is for the purposes of legitimate interests pursued by the controller. The one thing with legitimate interests, you need to make sure that it doesn't outweigh the rights of the individual, and it's in the individual's best interests. The main thing to look at in terms of sort of the repermissioning side of things of databases, the context of your business and the reason why you have and you're using personal data in the first case really is understanding this can then help you understand when it's appropriate to seek permission and or whether to repermission. So consent may not be the most appropriate lawful basis for processing, even if you're doing marketing, but as long as it doesn't negatively affect a person and relates to the products and services that an individual is interested in, you may not need consent. If you're using data for another purpose, you may have other conditions to rely on that don't require explicit permission. If you've already got, one thing as well to consider, if you've already got a record of consent, just make sure it's adequate. You can assess if it's adequate. If it is, then there's no need to spend time repermissioning or going through your database. If the purpose for which you're using sort of people's data hasn't changed since you've obtained consent and the consent was adequate, then again, there's no need to repermission. Consent and the other bases for processing should be subject to continual review. Appropriate processes and procedures need to support this, make the process less onerous, although sort of setting them up can be sort of a challenge in the first place. And just managing sort of customer expectations is key. Provide easy accessible options for people to opt out of any sort of marketing or any consent-driven processing that you're doing. And then it takes away sort of the repermissioning side of things a little bit from you there. Then So yeah, myth 3, we've got a mountain to climb. This is such a, we hear this a lot, there's a lot to get done, but actually if you break it down into small tasks, then it becomes a lot more manageable. The first part and the key part is to create a register of data processing activities. Think about the different areas of your business. Where are you collecting personal data from? What personal data is it? How do you process it? How do you secure it? Getting this stage right will underline your whole GDPR compliance program. So spend time on it and involve people from across your business. Get them involved in GDPR. One of the key areas again within having a GDPR project and program is around training and awareness and making sure people understand around sort of data privacy and what they need to do and what their role is within an organization, and what the company's position is in relation to data privacy. So if you can get people involved in the GDPR program from the very beginning, that will help with the sort of training and awareness and understanding across the organization as well. If you're looking at particular services that's going to be sort of collecting or processing personal data, look to do and record data privacy impact assessment. This is where you'll be looking at what risks are to the individual or the company by you processing personal data in that particular task. You need to consider what the risks are and think about ways that you could reduce the risks to the individuals. Controls such as things like introducing two-factor authentication if you've got people logging into a particular website, or if you're storing personal information, you may want to be looking at encryption and where you're storing it, or if you're sending it by email, encrypting that before you're sort of sending it to individuals, and looking at things like information rights management. And there's lots of different controls that you can put out there, but it's really understanding what the risks are, what you're doing with that data, what data it is, and making it appropriate for your organization. Another area that is a key area to focus on is getting your sort of data protection policy and your privacy notices updated. When you're doing a privacy notice, if you're obtaining personal data, the controller needs to provide the data subject with certain information at point of collection. So within your privacy notice, you want things like the identity and contact details of the controller or any representative that the controller's got, contact details of a data protection officer if you've got one, the purposes of any processing as well as the legal basis for processing. If you're using any legitimate interests, what are legitimate interests are being pursued by the controller or by any third party that comes in there. Recipients or categories of recipients of personal data, and the fact that the controller intends to transfer any personal data to any third countries, or if you are transferring data to third countries, what adequacy conditions have been put in place to protect that data. In terms of adequacy conditions, this could be things like privacy shield if you're transferring data to the US, or it could be additional clauses put in contractual clauses and so on. If data has not been collected directly, then you will need to contact the data subject within a reasonable time period of having obtained that data. So if you'll obtain data from someone who's providing you a list of personal data, you need to contact the data subject, say received your data from someone who's passed across your data from this list. They say maximum within 1 month when you're sort of collecting data in that way. If the data is used to communicate with the individual, make sure you contact them at the latest when the first communication takes place, again to let them know how you're going to be sort of processing your data or their data and sort of where you got it from. If you're looking to disclose to another company or another recipient, make sure you've again disclosed the data and how you're going to be sort of using that data to the individual before passing that data on to any other organization. You must also always pass on the source of the data, so whether that be purchased or publicly available on that side. The other areas is you need to when you're going through it, you need to understand your legal grounds for processing. So you'll need to go through your data register and make sure that you've understood whether it's consent or you're going by legitimate interests, or if you've got a legal reason for processing that data. So that's an area that you'll need to go through as a project. As I mentioned, there's a number of rights that individuals have now got under the GDPR. So you've got the right to be informed, the right to access, the right to rectification, the right of erasure, the right to restrict processing, the right to data portability, the right to object, and the right to have, if there's been an automated decision-making process, you've got to have the right to have that manually reviewed. Within within your sort of privacy notices, you need to put what the process is for an individual to be able to enact their rights, but within your organization you need to make sure you've put in place the various processes and policies so that people within your company understand what to do if someone has said, okay, I want to know what information is being held on me, from personal information is being held on me within the company, how they need to respond to that. They need to respond within a calendar month, but how that data will be found and how that will be packaged and sent to the individual. One of the key things here as well is making sure that you identify the individual before you send out any information to make sure that you're not breaching any sort of security regulations or privacy regulation by giving out data to the wrong person. Another key area to look at is looking at information security, so making sure that personal data that's being held within the organization has actually got the appropriate security controls around it. Under the Data Protection Act, more fines and enforcement orders were put out to organizations under Principle 7 of information security than any of the other principles put together. So it is a key area to focus on in terms of information security under the GDPR, making sure that personal data is properly protected. And then the other areas around data breaches and reporting, making sure you've got appropriate data breach reporting, reporting mechanism put in place, so if you do have a data breach, you can contact the individuals to let them know that the data has been involved in the data breach. It says that you need to contact the individual as quickly as possible, but no later than 72 hours. You don't need to contact individuals in every single case. If you've done a review and there's been a data breach and some data has been taken, but you believe that the security controls around that data makes it practically impossible for someone to be able to access that data, then you may not need to actually report it to the ICO or the individuals, as there could be no damage to the rights and freedoms of those individuals. But it could be best practice to just let them know anyway, but then let them know what security controls are around there, and then they can make their own decision. But that's one way of sort of looking at it. Then we're looking on to, myth 4. And you need to worry about sales and marketing data. This is the area within sort of GDPR that we see the majority of companies spending and focusing a lot of their time around sort of sales and marketing. There are a lot of other areas which I'm just going to again get these up on the screen. But the GDPR is not aimed at stopping sales and marketing of companies. Sales and marketing is a key area for majority companies. It's an area where they sort of will collect a lot of personal information. You also have a need to look at your employees, your customers, your prospects, your suppliers, your partners. They'll all fall in the scope of GDPR, so don't just spend all your time focusing on your sales and marketing area. This is also not just aimed at business to consumer. That's another area we hear. So it's all for B2C, business to consumer. If you're contacting individuals within another company, if you're doing B2B work, still collecting and processing personal data on them, must be treating it in an appropriate manner. As listed out on the screen here, you need to be looking at your key business processes, your sources of personal information. All this would be captured in that register of data processing activities that you would need to be sort of doing at the beginning of your sort of GDPR program. A lot of companies will be using cloud-based systems now to store and process data. So there's a lot of work that needs to go into making sure you've got appropriate contracts in place with your data processors. And a lot of the work that we've been doing with organisations has been going through and making sure that we've got the supplier management bit down, and we've got appropriate contracts in place so they know exactly how they can process personal data, what security we expect, and what we expect in terms of data breach reporting if they have a data breach, in terms of what they need to be coming back to us. Most of the large cloud providers now and data processors will have addendums on their website which you can search for. You'll need to download those, sign those, and send them back. So that's another area to sort of focus on. Another area I just thought I'd cover off on here is making sure you've got your retention periods for personal data agreed within the organisation. So there could be legal bases where you need to be keeping personal data for 5 or 7 years for financial reasons, but if you make sure you've got them documented, and then you're not holding data for longer than is necessary. So yeah, the fifth myth that we wanted to sort of go through here would be, it will be detrimental to my business. How can my business survive in this new world of GDPR? It's going to damage what we do on a day-to-day basis, and we just wanted to sort of go through some of the areas which we think actually can give great benefits to organisations. So obviously the first one is if you get GDPR right and data privacy right within an organisation, you're going to have decreased data security risks, which means that you're going to have less chance of reputational damage. Your customers are going to have more trust in you, and makes your organisation stronger, and more businesses will want to do work with you, especially as the GDPR is all about being open and transparent with customers around how you're using their data. So organizations will have more faith in the organizations and how they're going to be sort of utilizing their data. You're going to have narrower but deeper knowledge of prospect and customer databases. Whenever we go into organizations, it's been every organization we've gone into, their databases have got data all the way from the day they first started. They have thousands, hundreds of thousands, if not millions of people's data in those databases. Some of that data is so out of date and they don't communicate with those people all of the time. By making sure that you've actually only got the data related to the customers that you're wanting to work with on a day-to-day basis, you're having better communication with those customers. Those customers want to hear about the products and services and want to engage with the organization, so you're getting better relationships. So that's a really key area. Increased staff productivity. Again, if you look at staff having to go through mass databases, and they're going through data that is old and out of date and not relevant, then they're wasting a lot of time trying to contact people which are just not interested in the services that you're trying to offer. So there's increased staff productivity there as well. Have more effective targeted marketing, a stronger sales position, again, by having that database which is relevant and has the customers that want to work with you and are interested in your services, and you're going to have a higher take up in terms of targeted marketing and put you in a better position. And again, as I mentioned earlier, that improved customer relations and increased trust is an area which you'll get out of it as well. And then, yeah, as I said, training and awareness, that improved internal awareness, education, and culture is a key area to focus on within sort of GDPR and data privacy. Get the people in the company involved. GDPR can be quite a dry subject for people, and yeah, it's important to get people involved in it so they understand the reasons why the business is doing it, and that it's not just a compliance activity, but there's reason to really do it, and that it's a positive for business going forward. So that's it from myself on here. I'm just going to pass across now to Mike, who's going to go through the last myth.
Thank you very much, Anthony. That was very informative. It is obviously quite complex. but there's a lot to it. So please keep your questions coming. I'm now going to hand over to Mike to talk through the sixth myth. Sorry.
Thank you very much, Alison. Yes, I'm Mike Richardson, the Managing Director for Maximizer Software here in EMEA. As Alison pointed out earlier, we actually started looking at our own GDPR compliance and program and so on quite a few months ago now. And when we initially started looking at this, it all did seem, as Anthony said, it all did seem pretty complex. There was a lot of myths out there and so on. So that's why we decided to start working with Anthony. What I'm just going to cover a few things really around how Maximizer CRM product fits in with this, and hopefully give you some insight into the way that some of our customers are using Maximizer, and indeed how we're using Maximizer as well. So myth number 6 is mine, the one that I'm picking up. Our CRM provider is GDPR compliant, so are we covered? Well, this is an interesting one that we're being asked quite a bit, but we're actually being asked if Maximizer software, as it comes out of the box, is CRM compliant. And I think from what you've just seen through what Anthony's gone through, at the end of the day, Maximizer is just a tool. It's a bit of software. So essentially, Maximizer in itself doesn't have to be GDPR compliant. It's not required to be GDPR compliant. What it does need to do is to be enabled to be configured in a way which supports your business being GDPR compliant. So essentially, you can get Maximizer as it is out of the box. There are some things that help you immediately in terms of GDPR compliance. But as Anthony said, the main thing you need to look at are all your internal processes and where the data is coming from, how long you're going to retain data, whether you're going to work on the basis of consent with clients, whether you're going to use that legitimate business interest. Now, the great thing about Maximizer and the CRM products in general is they can support that. So we can add fields into the database, and we can add key field lists specifically into Maximizer that can help you record information that supports your GDPR process. So what I've mocked up on the screen is essentially what we have configured in our database at the moment. We're still a work in progress. We haven't finished with Anthony. We're still going through some things, but we have for example, I'll go through the heading. So Anthony mentioned that you may have a requirement for a data subject to actually request information from you, or to request what you as a company are holding on them as an individual. So we could use the CRM database to track that request. We could time the request, as Anthony says, you'd be expected to respond to that in a timely way within a month. So you could track the initial request, you could track the type of request. On the screen, I've just said someone's called us to say, can you rectify my data, as in, I believe the data you hold on me is wrong, can you correct it? And that's a fairly straightforward one, actually a very useful thing to happen, I would suggest. But the individual may also wish to have data removed or so on, or want to have indeed even have a copy of the information that you're holding on them. So we can add fields into the CRM database that help you to manage that side of compliance. We can help in terms of what the opting in and consent to receive various different types of information. There's 2 ways we can do this. Within the Maximizer product, we actually have built-in opt-in capability with our marketing campaigns module. It's actually built in there, and the opt-in capability is actually held against each email address. We also have the capability in the product to track to other areas, like for example, if we did have a data breach and we wanted to actually show that information in terms of the fact that we've notified people about that data breach. And there's some pretty common sense things about tracking the last time you contacted someone, how long you've had their data. Anthony mentioned that if you've got a customer and essentially you have a contract with them, you've sold them something, you have a contract to supply them with some product or service. So in that case, you're not too worried about, no, that's really covered under your business interest side of things. You're already doing business with someone. But if you have some prospect or someone you meet at an event and you're making initial contact with them, there may be a period of time you decide how long you keep that information. Now, as a prospect, they might not actually want to talk to you after 3 months, so why keep that information? So you have to think through those sort of things. And Anthony's helped us in our setup in terms of how we've done that at Maximizer. So on this screen, I've just showed you from our email campaign manager, we have these fields available that allow you to set opt-in types. And against those opt-in types, you can actually set those up against individual marketing campaigns. So you might, for example, have a newsletter type, you might have a products and services type of opt-in, and depending on which type of email communication someone has opted into, they will or won't receive that sort of communication. And what you'll find in Maximizer is that even if you add someone into that list as a subscriber for a given campaign, if they haven't opted in, then they will automatically be removed from the campaign when it goes. So if you need any more information in terms of how that works, just contact us here at Maximizer. Another area we can do, if we actually use the CRM solution as a tool to help us track compliance, we can then obviously start to use the reporting and dashboards within the CRM solution. Now, I think one of the interesting things we found out when we started looking at this really was that, in a way, the CRM part of the GDPR compliance almost tends to be the easiest part of it. We have the data in one place, we can change some fields in the database, and we can start to manage the data that's in the CRM solution. But as Anthony pointed out, companies tend to have data all over the place. You might have sales guys with spreadsheets hidden away on Dropbox somewhere. You might have email lists. You might have bought-in lists that people have. You might have your staff records, payroll records. They sometimes are a lot more difficult to actually control. And the more data I believe you can get into the CRM solution, the easier you can make it. Now, use the CRM as your tool for managing the data around the organization, as well as just your sales and marketing side of things. What we also did in terms of our GDPR compliance, obviously we have different ways of deploying Maximizer nowadays. Historically, we used to be just deployed in an on-premise environment where the software was installed on your servers in your office. Now, some of you, our customers on the call today, will still be using Maximizer in that way. So you have the data, you actually have the data on your servers, and essentially you're doing the data processing. What we also have nowadays, though, is the concept of cloud-based software. And we actually have our Maximizer data center in the UK, where we have clients that have their databases held in that environment. And as Anthony said, at that point, it gets a little bit more complicated because it's your customer data, it's your database, but it happens to be held in our data center in Milton Keynes. So what we've put together to support this, obviously our contracts have changed a little bit, but we've also put together a data sheet to explain to you how that cloud-based solution is set up. So it allows you to check that and put the tick box against Maximizer as you go through your GDPR compliance side of things. We've obviously, as we went through this, a few of you were asking us questions. I think we've got quite a long list, most of them aimed at Anthony, thankfully. at the moment. I'll read through them, and then Anthony, if you can, I think we'll probably pick about 5 off this list, but I think the best thing we'll do is we'll send an email out to people and just put them the Q&A with all the questions and answers anyway. But I'll pick a few of these off, the most poignant ones, I guess. Quite an interesting one here. Does a quote, as in a quotation sent to a client, class as a contractual obligation so that he can store his and her details?
Yeah, so in terms of what the GDPR states, it talks about when entering into a contract or having a contract. So yeah, you could use a quote as something which you're looking at entering into a contract and putting details on there. The same could be said, we've worked with other companies when you're looking at taking CVs, doing recruitment. That could be considered when about looking at entering into a contract with a potential employee. So that could definitely be yeah, an area which you could look at as a legal basis there.
Okay, I think one of the key things that sort of comes out of this when I've talked to you as well, Anthony, and now we've talked to other people, is that there are quite a few grey areas in this, and it's really down to a company in some ways to define their own best practice. Would you say that's a fair?
Yeah, true. I mean, in terms of sort of the GDPR and the way it's done, it's very much done as sort of a risk framework, as it were, and an organisation needs to go through it and look at everything as what the risks are to the individuals, which data they're processing, what the risks are to the organisation, and yeah, meet the GDPR and the risks and get the balance right for the company. I mean, obviously, for a small company that is not processing lots of personal data, there's no point in them spending a month putting a GDPR program in place. It's very much they need to look at what's relevant around the data that they're collecting and doing putting the right sort of processes in place and looking what the risks are around it. So it's just doing what's relevant for them.
Yeah, I mean, we've actually got a question around that, really. Someone's asked us, what's the difference between a business that really focuses on business to business and one that focuses on business to consumer, and what you would say the main differences you're likely to see in terms of how they may operate their GDPR compliance program? Yeah,
I mean, I tried to touch a little bit on that on the talk with because that is another area with sort of business to business, business to consumer. There was, I mean, I think a few people still going around saying, oh, if we just deal with business to business, do we need to do sort of GDPR? Yeah, and the answer is yes. I mean, you still need to look at GDPR from a perspective of your own employees. You need to look at GDPR where you're contacting your different customers, even though they're in organizations. The main difference, I suppose, would be around when you're contacting organizations or individuals within organizations from a business to business context. Under the Privacy and Electronic Communications Regulation, PECA, you can contact individuals by email as long as you're giving them always an opt-out from a marketing perspective. As long as they've always got that opt-out on those communications you've got with them, you can use that as a way of sort of communicating with them. Whereas you can't use that as a way of communicating via email to consumers within a business to consumer process. If you're marketing to individuals, you have to have either that consent or other legal basis for being able to contact them.
Yeah, I've got an interesting one for me, which sounds quite a poignant question, really. There's quite a few questions about older versions of Maximizer and whether they can be configured in the same way. I think probably because what part of the product I showed today was relatively new, and the ability to put key field lists and that effectively created GDPR form within the product. Certainly with legacy products, that would have been a lot more difficult. It might have even needed programming expertise. But what we'll do is take those questions separately, because they may be quite specific to which older product version you're on. Certainly, we would always recommend that you don't run old software. So we won't do the hard sell. We'll help you anyway. But obviously, with the newer products, it is a lot easier to configure it for this sort of thing. And we do have built-in things to the product like the opt-in. I mean, the opt-in won't have been in older versions. And to build that in would be very, very difficult, I would think, on the face of it. So another questions for you, Anthony. I'll just take a couple more. when purchasing business-to-business lists,
Mhm.
are they really subject to the same process? If would you be expected to contact everyone on the list and try and get consent, or is it
So,
best?
yeah, so for the business to business, when you're sort of purchasing these lists, again, you need to first of all make sure that where you're purchasing the data from, that they've collected the data in accordance with the GDPR. So make sure you're getting it from a reputable source. And as I mentioned, when you're contacting individuals for the first time, you should let them know where you've got their data from. So what organisation you've managed to get their data from and where that's come from, and that should be in sort of the first contact that you're having with those individuals. If it's purely for a business to business context, it comes back to a bit what I said earlier. If you're contacting those individuals and you're giving them an opt-out, then that's fine from that perspective, but it's best to be transparent and open with individuals. The more transparent and open around the processes and what data you've got and how you've got it, then more people will buy into the organisation and have a better relationship with the customers.
I've got a question here that I think I can answer anyway, so I'll try and answer it, and you tell me if I'm right. Putting my head on the block here.
Go for it.
This company have their customer's name, email address, phone number. They're saying it's a customer, and they're saying, do I need to get consent from them to hold? So my understanding is it's a customer. You already have a form of contract with them to supply goods and services. So you do have a legitimate reason to keep that information.
Exactly.
However, if you then communicating through email to contacts at that organisation, I guess best practice would be to get consent to the sort of information you might send them.
Yeah, I mean, no, that's pretty good on that side. I mean, I say the contract that you got with the customer is, you're having those communications with them under the contract that you've got in place there. If you're trying to market other products and services to people within that company that you don't have a contract for those particular products and services, then you would need some sort of legal basis for being able to contact those. But if you're contacting people within those companies, then and it's in relation to the contract that you have in place, then you wouldn't need any sort of other consent or anything in place. You've got that contract, so you wouldn't need any other legal basis in place as long as you're contacting them in relation to that contract.
It's another area that gets quite grey, I guess, doesn't it? Because the other product you're quite trying to sell may be related to the initial product you sold, or it could be something that's not really, it could be a totally different product, in fact. So it's quite an interesting one. I guess as a company, you take that decision again.
Yeah, and you've got the legitimate interests of the company. So again, if you're contacting those individuals and you think it's not going to be causing any harm to the individuals to contact them, and it's within your legitimate interests, then you can go through that. You just need to sort of do a fairness test or a review of whether you think people will have issues with that contact.
So we've got just one final question we'll go through, which someone's a distributor, but they're in I guess the UK or in the EU. They actually use a supplier database that's based in the United States. How does this work under GDPR? I guess you're going to say you haven't got enough information to answer. But,
well, I mean, if they're based in the EU, they fall under the GDPR rules. Even it doesn't matter where the processing takes place. It's if they're based in the EU, then they fall under GDPR, and they need to be processing it in line with the GDPR.
Mm. So there is one similar to that we got, was does GDPR apply to EU citizens that live outside the EU?
Yeah, so it would be well, if the data is being processed by companies within the EU and there's citizens, then it would cover under that side of things. The only people that excludes is anyone that falls outside of EU law.
So I think the main thing I would say there, if you're going to go through all this, it makes little sense to me to actually discriminate between where people are based. It's just best practice anyway, isn't it?
I mean, what we're seeing is that a lot of countries and areas are now starting to align to the GDPR. This is now being seen as the best practice for countries around the world, and a lot of other countries are now sort of putting in place privacy policies, or looking to put privacy policies in place aligned to GDPR. So we're seeing it in sort of South Africa, seeing it in Asia, and you know, we could be seeing it across other countries as well. I mean, we've got a lot of clients now in the US and in Canada that are now sort of looking at the GDPR as sort of de facto, and making sure they treat everyone the same, because it is easier than trying to sort of look, all right, okay, we're just going to deal with just EU citizens in this way, or people that are based within the EU in this way. We're going to deal with the rest of the world another way. It's sort of easier to just have one set of policies across an organisation rather than lots of different ones.
Okay.
Cool. So I'm going to hand back to Alison now. Thanks for your questions, everyone. As I say, we'll get them written down anyway, because there are some more questions on top of it, and then we'll email those out to you in sort of a Q&A type document. So thanks very much for those.
Yeah, thank you, Anthony. Thank you, Mike. So before we sign off today, I just wanted to chat through resources that are available to you. So the best resource is to go to, if you're in the UK obviously, is to go to your supervisory body, and in the UK that's the Information Commissioner's Office, and we've got the website address here. I practically refer to that site on a daily basis now. You know, if you need to delve into the regulations, that's the place to go. We also have been building quite a lot of resources for our customers and our prospects. So on our website, we have a GDPR information hub, and the URL is there. That's a page that we are constantly updating. In fact, a lot of the questions that you have kindly been asking us this afternoon, the really sort of the top ones will go on to that information hub as well. So please take a look at that, and as I said, that's regularly updated. If you want to kind of measure where you are with your existing data management, we have a data management test, which we can give you a scorecard and recommendations off of that. We have a series of GDPR emails, GDPR Essentials. Again, that's available for sign up through the GDPR Information Hub. And for our customers and actually for prospects, we have a GDPR compliance program. And this is a program that we've put in place for our customers that is a joint project with Anthony and his team. So the majority of that program will be supplied by Anthony, including 21 hours expert advice, tools, guidance, and templates. So if you're an existing Maximizer customer and you're interested, please get in touch. If you're a prospect, again, please get in touch with us, because we can offer that program even if you're not with Maximizer as yet. And then, as Mike said, we are, we're looking at how we can sort of use Maximizer to deliver ongoing GDPR best practice, and we'll have guidance notes. And we, in our customer success team, that's something they will be able to talk to you about as well. So that's the end of the webinar today. Before you go, just to say we will be sending out a recording and the Q&A sheet with the replies. Do get in touch with us at the email address on screen. We did have a poll open, which I understand you can't access as yet, but we're now going to make that available. So hopefully you can gain access to that. And we'll leave the webinar open for a couple of minutes, and hopefully for those that are still on, if you don't mind taking the time just to quickly answer one very quick question about where you currently are on your GDPR journey, that would be very helpful. So thanks again for your time today, and if you do have more questions, do just email us. Thank you very much.